welcome to Moneylife News and Views. India has been struggling with bankruptcy resolution for a very long time. And I'm not talking about personal bankruptcy, I'm talking about corporate bankruptcies. You must be reading headlines in newspapers saying, so and so company owes the bank 7,000 crore, 10,000 crore, 15,000 crores, and so on. Now, corporate bankruptcies never had an easy way of handling in India. And the reason for that is that India has always made a mess of it through a variety of rules, regulations, especially new laws that it kept on coming out with from time to time. The last major law reform that had happened was sometime in 2001, I think, when we had what is called the SARFAESI Act, which is securitization, etc. It's a long name. Now, that was supposed to have changed a lot of things, and bankruptcy was supposed to be very easily handled. Unfortunately, that got bogged down with a variety of cases, new sorts of further rules, judgments and counter judgments, and so on and so forth. So the UPA government, which is the one which is before the BJP government, which is now currently in power, had thought about something called a bankruptcy code. Now, IBC, that is the Insolvency and Bankruptcy Code, was supposed to be a completely fresh and a new beginning in handling corporate bankruptcy. There were very, very strict rules prescribed in the law, like within 270 days you're supposed to resolve bankruptcy and so on. When the act was promulgated sometime 3 years ago, I wrote a piece which said that this is not going to work. It's probably going to be as messy as the laws that we've had so far. And the reason for that was nothing to do with the law as such, but the way in India we implement laws and the way we place a tremendous amount of reliance in new laws and new procedures without thinking about what has gone wrong and why did past laws did not lead to the desired outcomes. And that, unfortunately, is not something many people are focused on. And that is the role of the state, the role of the courts, the role of the rules and procedures in creating a bigger and a bigger mess in which everybody gets bogged down, and then eventually the businessmen see it, they find ways to game the system, there are enough of touts and other people to help them, and then eventually there is a stalemate, and then we think of another new law. Is IBC going the same way? Well, possibly it is. That's what I think. And 3 years ago I wrote that because we have placed so much of faith in a new law with a new superstructure, a new regulator, and new market participants called resolution professionals and so on, it was a huge bureaucratic superstructure that we built, and I felt that this is going to be exactly the same as before. Unfortunately, as it turned out, I was right. Now, not only do we have the IBC codes being openly flouted. For instance, there are so many cases which are not getting resolved within 270 days. Now, only about 79 or so cases have actually been resolved under IBC. And then we've started getting different kinds of court judgments and different amendments to the Act, which all means that previous owners are able to bid for their property for the assets once again. And also, one of the most dangerous things is that the committee of creditors, or the bankers, let's say very simply, the lenders who have lent the money, and the promoters, the businessmen who have run the business to the ground, may find a way to create a deal for themselves if 90% of the creditors agree and come out of IBC and not go through the process. Now, I'll just give you a few examples of what's going on in the area of bankruptcy when a lot of people think that IBC is a fantastic new thing and it's working very well. Now, here are some facts. Just ask yourself, why is a spectacular crash landing of Jet Airways out of the IBC process when public sector banks, which are as usual deeply in the dock, ought to have reported about this bankruptcy case more than 4 months ago? The National Companies Law Appellate Tribunal recently passed an order that will allow promoters to settle with creditors even after the company has gone into liquidation under the new insolvency law. Now, if you have been paying attention to the bankruptcy situation, you would remember there was a new amendment to Section 29A, which was designed to prevent defaulters from getting back control over their companies. Now, if NCLT has recently passed an order that makes it very easy for precisely the existing owners to come back and get hold of the assets, which Section 29A is supposed to stop. 6 months ago, IBC was amended also to include what is called Section 12A, which allows withdrawing insolvency proceeding against a corporate debtor if 90% of the committee of creditors agree. Now, since then, as many as 80 cases have been withdrawn using this provision, almost double the figure of the past 2 years. Now, what does this mean? It means unaccountable public sector bankers and promoters can continue to have fun. These companies will probably get new fresh loans, which will go bad again. Now, in one particular case, which is a Swiss ribbon insolvency case, the Supreme Court even has said that insolvency proceedings can be withdrawn before the constitution of committee of creditors, even after the case has been admitted in the national law courts. I mean, this makes no sense. The IBC process has to be very linear and very fast and very clear-cut. Now, here is some data. The data available till September last year shows that financial creditors could get back only 25% of the claims, which is no better than the pre-IBC days. So 3 years, not much has changed. In fact, I feel this figure is going to go down because some of the better known cases have already been resolved. And now there are a lot of these smaller cases which are not going to be resolved or will come out of the IBC. In fact, if you just take, if the data for withdrawn cases is counted, then this figure, the percentage of recovery figure, will actually be much lower. Now, after the Supreme Court struck down Reserve Bank of India's February 12 circular, which the circular had said banks to classify a loan as stressed even there was a 1 day of default, now the Supreme Court has struck that down. So the pressure on companies to pay and banks to recover has drastically reduced. In any case, the public sector banks do not have any specific targets. Nobody is motivated. There is no incentive for them to recover money, and there is very, very little accountability over there. Now, once Supreme Court has struck down this circular of RBI, the banks will be even less, driven to recover the loans. Now, here is something which is really scandalous, and all of this was bad enough, but here is something really scandalous. Andhra Bank and other lenders attempted to push through a sharp haircut. The haircut means how much of money that banks can write off, and a one-time settlement with the fugitive defaulters of the Sandesara group of Sterling Biotech. This is really a big fraud. While in Sterling SEZ, where a similar deal was proposed, the NCLT has directed the government to take punitive action against senior bankers for misleading the tribunal with a withdrawal plea. Let's just imagine, you have a new law, and yet bankers and promoters are getting together to play these tricks. According to the IBC, applications have to be admitted within 14 days. The legal infrastructure is so poor, and that courts have decided that 14 days is not mandatory. And so in many cases, reportedly have not even been admitted for more than a year. And this is where the IBC is headed. The government had planned 27 bankruptcy courts to start with. Now only half of them are functioning. And finally, there is one company called Liberty House of UK, which the owners, the Guptas, keep coming here and give interviews to Economic Times and other business papers about their plans. Now they bid successfully for 2 assets, which is Adunik Metals and Amtech Auto, and they eventually didn't pay. This is where the whole process completely breaks down. It's a really mockery of the process. Now, this is just what has happened within 3 years. There is not going to be any change in this scenario. Things are going to get worse and worse and worse unless something drastically different is done. And what is that drastically something different? It is very simple. Just learn from how bankruptcy is resolved in advanced capitalist countries like the US. Create a distressed debt market. Let the market discover. Why go through this process of resolution professionals and regulators and courts and judgments and sections and so on? Every asset has a value. The value could be 1 rupee, 10 rupees, 15 rupees to on a on a 100 rupee basis. Doesn't matter. Let the market discover that price. Let them trade each other. Whoever has bought, who sees value in it, let them take over and run the company. If not, let it get liquidated. And this is a model which is followed by Western countries, mainly by the US. It's a very simple, transparent and effective model, and we should adopt it as soon as possible. But will we? Thank you for watching.